After your claim's been denied and you've exhausted all of your appeals in an ERISA claim, the only remaining option you have is to file a lawsuit. And you've probably, if you're contacting us at this point and watching this video, you've probably received a letter with a denial letter which says you've exhausted all of your ERISA remedies and now the only option is for you to file a lawsuit. So I'm here today with Rachel Alters, who's one of the disability insurance attorneys who's litigated hundreds of ERISA denials. And I want to talk about that process of what happens from once everything's been denied and then filing a lawsuit, and some of the pros and the cons of ERISA, because mostly we hear out in the media and we preach a lot about the negatives of ERISA,
Right.
but there can be some positives of having an ERISA versus a non-ERISA claim. So the first thing let's talk about is the differences between, if you have a private claim versus an ERISA claim. What are some of the
Sure.
biggest things that come to mind for you?
Okay, well, one of the biggest differences between an ERISA claim and a private claim is ERISA claims end up in federal court. Some private claims can, but most ERISA claims are in federal court. And you are in front of a judge. You don't get a jury trial. So that's, can be seen as a negative in some situations. But that's one very important distinction.
I guess that could be a negative or a positive.
Depends on which judge you end up in front of, I
Depends
suppose.
which judge you get. You never get a jury trial
Nope.
in ERISA. So really, people talk about, well, I'm going to get a lawsuit, I get my day in court. Well, you get your case, your ability to file a lawsuit in federal court, but you don't really, in my opinion, get your day in court because you as the claimant will never, ever see the inside of the courtroom because you're never allowed to testify. The judge will never require you to come to court for that matter, and it's possible that us as your lawyer or any lawyer that you hire may never have the opportunity to even argue orally your position because the judge may only allow us to submit a written motion, which is called a summary judgment motion or a motion for final judgment.
Correct.
So depending upon which judge you get, that could be good or bad. And some people may say it's not good to have a jury. Other people would say I only want a jury, but juries are completely unpredictable.
Right.
So that's one of the first things that's a huge difference. What about, if I'm thinking about I just got denied, what's the average time frame from once you file a lawsuit until you actually get this final motion/trial deadline?
Right. It depends, again, who the judge is. The average time limit is about a year. Some judges fast track it, and they want their trial dates sometimes within 6 months.
Right.
So it depends what the judge decides, but usually it's about a year.
Okay.
Yeah.
The other thing that I think is the standard of review, which is somewhat complicated. There's a lot of literature out there about it. We've done a lot of videos about it. There's many states that have said you can't have what's known as a discretionary clause, which says the insurance company has the ability to interpret the terms of the plan and make the decision on payment.
Right.
And therefore, if they do, the courts basically have to apply this arbitrary and capricious standard, which basically means you, judge, have to defer to the findings of the insurance company unless you can make a finding that they acted unreasonably.
Right.
And that is basically no matter if that's there, which it's in most policies, the discretionary clause, then the claimant has their back up against the wall. If you had two scales, they're already 60-40
Right.
with the disadvantage because the judge already the law is saying you have to lean towards the insurance company unless there's something out there. So how do you overcome that, when you're presenting these motions to get around that arbitrary and capricious standard?
Well, there's a couple different ways you can attempt to get around it. One of the ways is if there is no discretionary clause in the policy, then you can make a motion to the judge saying that we want de novo review, which is a standard that the judge looks at the entire case with a fresh set of eyes, and as if he's the insurance company. And if there's no discretionary clause, that's one of the ways. Other ways to get around that arbitrary and capricious standard is to show that the insurance company had a conflict of interest. So if we can prove that there was a conflict of interest, and that can be shown in many different ways, if you can show the insurance company was the payor and the administrator, that's a conflict of interest, which doesn't happen often, but it can happen.
Right.
And then we can get a de novo review based on that. If the claimant wasn't given timely notice of the denial, or if they weren't given a reason for the denial of their benefits, that's also a reason for de novo review. So there's several different ways you can get the review de novo, which is much more.
So those are some ways maybe to get it to de novo,
Yeah.
but how do you get to push the judge or show the judge that they acted arbitrary, that they abused their discretion? What are some of the things that are common arguments in these kinds of cases to say, hey, judge, I know we're going to accept the fact that it's arbitrary and capricious review,
Right.
and you have to err towards them, but they didn't act reasonably, and here's why. What are some of the classic arguments that come up when you're taking that position?
One of the arguments that we often make is when the insurance company will deny benefits and they don't do any kind of examination of the claimants. So they don't send them for an independent medical exam or a functional capacity evaluation. They're not seen by any doctors whatsoever. When they have their doctors just look at the medical records, which we call a paper review, and they make a decision and a determination based just on that alone. A lot of times we say, hey, that's arbitrary and capricious, especially if they have a doctor reviewing the records who is not qualified. So if there's a person who has back issues and they have a nurse look at the records and say, well, I don't believe that this person's disabled, that in our mind is an arbitrary and capricious review of the claim.
Right. So that was actually two different things you said. But they are required by law to have the appropriate medical specialist look at it. So if it's a back injury, they'd have to have an orthopedic doctor or a physiatrist or some sort of doctor who deals with back issues to look at it, and often they may not do that. I mean, some of the other things we argue is that oftentimes we have claimants who are approved for Social Security, yet the disability company completely ignores the Social Security file.
Correct.
So that's a big problem if they do that. That would be an abuse of their discretion. Some of the other things is that, our claimants send in extensive medical records and their doctors completely ignore that medical information. So there are lots and lots of arguments. However, for every argument that we come up with, there's cases all over the country, because every day there's another ERISA opinion that comes out from judges all over the country, and we track all of those and handle these cases everywhere. And for every one case that comes out favorable for a claimant, there's another one that says, well, just because the insurance company did this, we don't find that it was unreasonable. And another judge looks at the same facts and says, yeah, it was unreasonable. So the cases are all over the place, and it's important to hire a law firm that's on top of all that case law and knows how to make those arguments. Once you present all these arguments, you submit your 20-page brief, very extensive, takes you 100 hours to put this together and get everything into the court. What are potential remedies that a judge could do in ruling on the case?
That's a very good question, because it can go on several different ways. A judge can look at the motions for summary judgment and decide, obviously, that the insurance company was right, and then
it's over.
It's over.
Okay.
And you lose your case. If they decide in your favor, the judge can award past benefits, which are all the benefits that you're owed up until the date the complaint is filed. And then the judge can remand the claim back to the insurance company again for further review to determine whether or not the claimant is still disabled.
So the remand option means the judge doesn't make any determination on whether or not they're eligible for benefits, but gives it back to them again to do it again?
Well, they can say, we believe that the past benefits are owed, but we don't know that the claimant is disabled into the future. So we want the insurance company to do a review to determine whether the claimant is still disabled. So then it's all back on the lap of the insurance company to decide yes or no. And if they say no again, then you're back to doing another appeal.
But the judge can also remand and say, I'm not even telling you to pay the past due benefits. Also, you need to look at this again because, let's say you didn't use the right doctor. The judge can say, I'm giving you another opportunity. Go back and get the right doctor.
That actually happened in one of my cases.
Okay, and that seems like you win the battle but lose the war?
Correct.
So that's, and unfortunately, we know from all the cases we review that happens 70% of the time. That these judges do a remand because they won't take the initiative or feel like they're going to get reversed on appeal. I don't know what the problem is, and I'm happy to sit down with the judges and address that with them. But, make a decision on a claim and pay the benefits. If they screwed up, you should pay. Unfortunately, the judges don't do that, and I think that's wrong. The law should require them to do that if they're going to remand it. But when it goes back on remand, and we've been through this many times, What happens now? The insurance company gets the file and they review it and say, we still think you're disabled. Now what does the claimant have to do? What are the options?
They're not. They think they're disabled, or they're not.
No,
disabled.
you're still not disabled. It
Still not
goes
disabled.
back on remand and we go,
Right.
okay, we did what the court said. We still don't
Right.
think you're disabled. Do you have to appeal again?
You can appeal again, yeah, and
Okay.
then you're back to the drawing board. So essentially, you're appealing again. You have 180 days to appeal. They have up to 90 days to make a determination. If they still uphold that decision, then you're back to filing another lawsuit. And so this could be a vicious cycle.
Yeah, I was going to use that word as a vicious cycle. And that's
Yeah.
why when we read these cases
Yeah.
and we blog about them all the time on our website, you see cases where the person was disabled 4 or 5 years ago,
Yeah.
and you're finally getting a decision out of the court 5 years ago. And then how's that person supposed to feed themselves and their family for 5 years without getting paid? And obviously the answer is they can't.
No.
They do whatever they got to do.
Right.
But that's the tactic of the insurance company, is to try to bleed out the claimant to the point where they can't hang on to that long. And
Right.
unfortunately, we have clients who are forced to reach some kind of settlement with the insurance company because they say, I just can't go the distance anymore with this company, or the law is so bad against us with ERISA or whatever it is, and we need to settle. So
Yeah.
those are real life scenarios that happen and what insurance companies know. But there are a majority of cases that this is I think a bright spot for claimants who are watching this, where when we file a lawsuit, I would say a majority, I would say almost all of them, where at some point in time there's going to be some kind of financial offer on the claim prior to having to go to a trial.
Yep.
So, a lot of people think, oh, they're dead to rights, or we're just not going to win, or they throw it away, or they don't file a lawsuit. But if we look at your file and we think it has, is meritorious, we're going to end up being able to get you money. It's not a guarantee. We're not able to do that. But from our expertise, we wouldn't take the claim if we didn't think we weren't going to be able to get you some kind of payment, on your claim.
Absolutely.
So if you have, and this was just a brief summary, because when we litigate this, as you know, we had a case, we filed a ERISA lawsuit. It was one I did with one of the other lawyers of the firm. We had over 1,000 hours in the claim.
Right.
One of the nice things that reminds me that if you do win an ERISA lawsuit in court, regardless of the other state's laws, you can be awarded attorney's fees.
Right.
And I know you've been through that process many times. What is that like in order to get an award of attorney's fees for a claimant?
Well, that it's also up to the discretion of the judge. They can decide to award the attorney's fees and costs. Most of the time they do if you're the prevailing party. And it's actually nice because if you did spend 1,000 hours, then the judge looks at it to see what's reasonable for your hours, and they award you back, which the client reaps the benefits of those attorney's fees and costs, which is good for them.
The client gets the benefit of the attorney fee award
Yep.
because while they may have hired our law firm on a contingency fee basis, basically the court awarded fees would cover most, if not all, of our attorney's fees. So then it ends up not costing the client anything
Right.
to end up having a lawyer, which is a really nice thing.
Right.
The flip side of that is that probably 95% of these cases don't go to a final motion, so it's not often that you get an attorney fee award because it is very hard to win
An ERISA case.
an ERISA case. And it may not even just be the difficulty, it's the time frame that we talked about to get to the point where you could win,
Sure.
an ERISA law. Plus they appeal. And we didn't
Right.
even get into, what you win your suit at trial, almost inevitably they're going to appeal.
Yep.
And how long does that usually take?
A long time.
It's like another year and a half. So,
right.
and then you got to go through all these motions again, and then the appellate court could reverse it, and you're all back again. So, whatever stage of your claim you're at with a lawsuit, or even if you're still in the appeal stage, we handle the claims at every stage. We handle them all over the country. Feel free to call myself, Rachel, any of our attorneys, no matter where you're located. We'll be able to review your claim right away, give you a free consultation, and let you know if we can help you right away.